Interesting story here, and I'm a little confused, which is why we have got ex-small business spokesperson Leah Trask in to talk about this proposed legislation. It's a new bill, and I'm pretty sure it's a members' bill, caked-in bill, that a new members' bill to the ballot, to help employers and employees avoid costly unfair dismissal or personal grievance claims. Ms. Trask has introduced the Employment Relations Termination of Employment by Agreement Amendment Bill would allow employers to open protected negotiations for the termination of an employment contract. Okay, interesting. So Leah Trask joins us now. Laura, can I call you Laura?
You can call me Laura, thank you.
Okay, Laura, welcome to the program.
Thank you.
I read this initially and I thought, that's not a bad idea. And then I thought, well, what problem is it trying to get round? Can you tell me first, what is the problem with the way the law acts at the moment? A restructuring, someone can be made redundant, or if they are really crap at their job and they fail to do it properly, they can be dismissed. People have notice periods. I mean, what's the issue with the way things are now?
Yeah, look, so just firstly, this wouldn't actually change the way things are. It would just be adding something additional to the toolkit. But the issue really is that the dismissal process is quite lengthy, quite difficult for an employer to navigate. But also it's actually just really stressful for an employee. And there's quite a lot of questions in the air. What is actually justifying a dismissal? So you see a lot of personal grievance cases coming back on an employer when they feel that they've done the correct thing.
Yeah, I know.
And it can be, and that can be real stressful for the business owner too. So it's about just having that opportunity to have a conversation about someone's employment. And it could be that, someone's not obviously instantly up for dismissal at all, but it could just be that they've got some things going on, whether it's in their personal life that's coming into work, whether it's their performance over time.
Or they think the boss is an a-hole.
I mean, there could be some of that. The relationship could
or
be breaking
no one's
down.
happy and it's not working out.
Yeah.
Okay, well, that's why we have employment contracts that have safeguards and provisions and methodologies for dealing with that now, Laura.
They do. But often once you start some of those processes, the relationship breaks down even further. And that can pose a few risks to the business. I've had stories and emails of people during the dismissal period where an employee is like, right, well, I know I'm on my way out. So they, petty theft starts occurring, or they steal, some sort of...
or ridiculous things like an employee saying, I'm not coming into work, you can only talk to me through my lawyer.
Pretty much.
From what I've seen happen in cases like this, and I've heard anecdotally, is that basically the lawyers make a lot of money on both sides. And it's in their interest
100%.
almost to get things to go litigious and get things before the employment court, because that's their bread and butter.
Well, there is an element of that. I think there are lawyers that do want to help businesses navigate this legislation because it is quite grey. Yeah. But I agree with you. I do think that it is at the moment the only people that seem to be winning. It feels like are the lawyers. So having something that is it's on the side of the employer. And to be honest, if the relationship started to break down, this conversation would come as no surprise to an employee, and there can be some wins for the employer.
Yeah, but Laura, you are still fundamentally, and I guess you've revealed why this I don't think will get through and why you're going to get dumped on for it. You've said this is all about the business. This isn't actually about the workers, is it?
I actually completely disagree with you.
Well, you just said exactly. You said it was about the business just a moment ago.
100% it's for the business, but it's also for the employee. So hear me out a little bit on this. So I think that a dismissal process is really stressful. We already know that constructive dismissal is happening. It is illegal, but it's happening. And I think that actually a costly personal grievance claim, it's a bit of a gamble for both the employee and the employer. So I actually think that while...
Well, often people taking
it
PGs
looks like it maybe
end up paying way more in legal fees
100%.
than they can ever possibly hope to recover from any judgment in the employment court. And their lawyers, often unscrupulous lawyers, don't tell them that.
Well, that's the thing, and I think that it is a bit of a gamble, these cases, and it's extremely stressful. So, if your employment seems to be breaking down and your employer comes to you to have a conversation, that's protected. So there can be no personal grievance come back on the employer to have this conversation, and they offer you a settlement. Or
does that also mean you can say what you think in these protected discussions as an employee? You can tell your boss
100%.
that he's an absolute gobshite, and that's not going to be thrown back in your face?
100%. These conversations are completely protected, so no one will be able to have any kind of...
Would these conversations take part with legal counsel present?
They definitely will. It's up to you whether you want to have an advocate or a lawyer with you.
And who would pay for that?
Well, at the moment, I haven't really considered that. There's something that I would probably need to
I
think
think
of,
that's important because this is basically, this is, as you said, primarily a way for businesses to operate more efficiently or effectively and move people on who aren't working out more effectively. But I don't think that any employee would be comfortable under those circumstances going into a protected meeting without having legal advice as to what protected means and what their rights and obligations are in that meeting. And that's a cost to them, and I think that's a cost if the employer is reaping the benefit of being able to get rid of this person with a negotiated exit is what we're talking about. Then I think the benefit of that cost goes to the employer. They should pay for the employee's lawyer.
And you know what? That's a really good point. And if this bill was drawn and did make it through the first hurdle, this is something that the Select Committee, I would expect, would recommend. So, very good point. And I agree with you. I also think that it shouldn't be worn at all by the employee because it's essentially the employer's decision to call the meeting. So, yeah, I agree with you.
All right. Laura, why did you draft this bill? Have you had small businesses come to you and say this is an incredible problem for them?
Definitely. When I'm out and about talking to small businesses, we often talk about employees and employment, and hearing their stories of whether it's employees that have caused them a lot of grief, or whether it's situations where they feel that they've followed the complete process correctly, and then an employee's come back on them. And sometimes this employee could have felt like a member of a family to them, and it comes as a real shock. So it's really about...